This episode is brought to you by Roundtable Group, the experts on experts. We've been connecting attorneys with experts for over 30 years. Find out more at roundtablegroup.com.
Welcome to Engaging Experts. I'm your host, Noah Ballmer, and today I'm excited to welcome Tatevik Torossian to the show. Ms. Torossian is a director of Grobstein Teeple, LLP, a litigation consulting and forensic accounting group. Additionally, she is a forensic CPA with over 15 years of experience and a sought-after presenter. Ms. Torossian holds a BS in accounting and business management from Cal State, Los Angeles. Ms. Torossian, thank you so much for joining me here today on Engaging Experts.
It's a pleasure. Thank you for having me.
Of course, let's jump into it. So you've been a forensic accountant since at least 2009. How did you first become involved in expert witnessing?
Yes, that is correct. Since 2009, and I would say that I always liked investigative work. I, at some point, considered becoming an investigative journalist. However, a friend discouraged me, stating that it's a bit risky and it may not be very positive experience for, if you want to settle later and have family. And he suggested I look into accounting. And I did so, and then discovered forensics at some point. And it was a perfect match, combining numbers, which I really liked, and investigative work.
Sure, of course. And tell me about the first time that you got called for an expert witness appointment. Were you looking for that? Is that something you were advertising for? Did you even know about expert witness work? How did that go down?
I did not know about expert witness work. I did financial accounting during my college days when I was studying for the CPA exam. And then upon completing the exam in 2009 is when I connected with a boutique firm in Pasadena. And all they did was forensic accounting, which was quite the new area for me. And when I was introduced to it, I embraced it, and I have not looked back, and I have not stopped doing that. Initially, during those beginning years, I was supporting the partners at that boutique firm, meaning I would dig into the cases and analysis and reporting in their support of the case. I did not testify directly. However, throughout the years, I became more and more excited about testifying myself, which for the first time occurred in 2022 when I first was designated as the expert directly.
A lot of people have a lot of different preparation techniques when it comes to depositions and cross-examination. Some people like to, cram their expert witness report the night before. Some people like to caffeinate themselves or do yoga. Do you have any pre-trial or pre-deposition routine that works for you?
Yes, I would say know your report and know your analysis. And not the 24 hours before, but the week before, the several weeks before. And hopefully counsel had retained you early enough to sufficiently dig into all the records and documents that came your way, and that you are prepared to address any of the strong points of the opposing side against you in particular.
So you talk about making sure that there's sufficient time. Now, this is a mantra that I've heard from a lot of expert witnesses. Attorneys, please give us enough time. Do you typically have sufficient time to do everything that you need as thoroughly as it needs to be done in an expert witness engagement, or are there certain occasions that you wish the attorney would have engaged you a little bit earlier?
The latter is correct. Yes. More often than not, experts are engaged later in the process, but there are many cases where they are engaged months in advance. And in my recent trial case, we were engaged the year before, and it was a tremendous success for the client.
So when you say the year prior, were you aware that you had that much time, or was it something that just kind of got drawn out that long?
Good question. Initially, they thought settlement or negotiation talks would go into maybe about 6 months at the time, as of the time of the engagement. So 6 months after that, within 6 months. And those negotiations failed when the time came. And as a result, within months of it, the trial was scheduled.
Do you find that a significant number or most of your engagements actually move towards settlement?
That's the preferred, obviously, right, goal, because it's just cost effective. And in this particular case, the plaintiff, I was supporting the plaintiff side. Plaintiff had offered many times to settle the case, but he was the defendant that opposed settlement. And when all those failed and the trial commenced, it was all end result was all to the benefit of the plaintiff. So the defendant really missed out on the settlement opportunity. And the same thing happened again in my last arbitration trial. And the defendant refused to settle, and the arbitration was in favor of the plaintiff. So while many tried to settle, it really depends on a case, I would say. But ultimately, when it does go to trial, one side prevails. You hope you're on the right side.
You're right. A lot of these cases are definitely moving towards settlement. How does that affect expert witnesses? Does that take work away from you when when ultimately attorneys are trying to push to something towards settlement, because then you won't have the opportunity to do as many depositions or be in cross-examination, all that sort of stuff? And if so, is that something that you protect yourself from by adding terms to your engagement letters, such as non-refundable retainers and items like that? How do you protect yourself to make sure that you get paid when some of these actions move towards a rapid settlement?
Well, again, thank you for asking that. I think it's important to note that we bill on time spent, time and material. So, and we bill on ongoing monthly basis. So whatever work is performed up to the date of settlement, it's expected that the client will take care of it.
Sure.
In other words, you won't incur additional billable time because depositions and trials are expensive. But whatever work is done up to the point of settlement, that's expected to be compensated. The expert is expected to be compensated. And I usually never put any special terms in contracts about non-refundable retainers and whatnot. It's usually whatever time and material has been spent and incurred for the case, we bill on a monthly basis.
So one of the things that you mentioned was arbitration. Now, a lot of newer expert witnesses don't know that expert witnesses are also used in alternative dispute resolution, such as arbitrations. Tell me how these sorts of matters are different for an expert witness from an arbitration versus a normal trial.
Yes, so the trial I was in, for example, in June, was supposed to be 5 days. It ended up extending over a 3-week period. It was a jury trial. So that means there are 12 strangers deciding your case, and also 12 citizens that may not have any accounting background, most likely they don't, and most likely they don't keep a checkbook, right? They don't reconcile their bank accounts. Those are all foreign thoughts and ideas to most of them sitting there, and no legal background either,
Sure.
most likely. So that's one big aspect of a jury trial. So you have a very layman audience that you need to communicate your findings to. And then you have the arbitration, where it's a judge, most likely a retired judge, that is presiding over the case, who will tend to have more knowledge and background in financial aspect, legal aspect, likely has been exposed to more cases, has heard a lot of cases. So the audience is different. However, I find it that my communication remains similar. I will communicate as simply, as clearly as possible. And in my view, even if the trier of fact is the judge sitting across, I would still assume that I need to explain in the simplest form possible. But yes, the main difference is the jurors versus a judge presiding.
So, assuming that everybody is a lay person, even when you have a fairly sophisticated judge, they might not know all of the intricacies and ins and outs of your profession. What are some of the techniques that you use to communicate some of these complex topics in a way that's more easily digestible to laypersons?
So topics, it would come down to, it's a dispute, right? It's a dispute about money. And many times it's money, where it came from and where it went. And if it went to the wrong parties, how much, right? So it comes down to how we can demonstrate this money in the simplest form. The party had X amount, now they have Y, and therefore they're entitled to the difference. Or in my trial case, it was heavily based on a bank statement analysis, and really, ultimately, the jurors really relied on that fact that everything was documented in the bank statements. So there was no lying as to what happened because it was traced all to bank statement, versus opposing counsel chose to reinstate historical invoices without consideration, for example, for bank transactions. So one is an internally created document.
Sure.
The other one is an external third-party document, and you have to decide which one is more reliable. So yeah, choosing most reliable source information and presenting it.
Have you used demonstratives in your field? In other words, charts, graphs, pictures, videos, things like that?
Yes. In the trial for the jurors especially, it was extremely helpful to use a very simple demonstrative where it showed $100 was deposited, $50 went out, $50 was left. It should have been split in two parts between the two partners. It was not. So it was over 3,000 transactions. And many, many disbursements that occurred, but we condensed it to one line item and condensed the deposits into one line item. Don't even break it down by year, just the total in the claim period and the total that went out. Just one number came in, one number went out, and what remained, that's the number they wrote down. Yeah. And if you have components like adding interest or adding unpaid costs, again, it's just the one number. It's 3% on that. So they know exactly what they're looking at and what that number represents.
Is this something that you tend to produce yourself, or does your firm make these, or do you use third parties to create demonstratives?
Usually for complex cases, third parties. In this particular case, the legal team actually did an amazing job. They had internal team that was assisting with the demonstratives, and they were really helpful and resourceful. Yes.
How does that process work? Tell me a little bit about the types of communication. I'm really interested in these demonstratives and how they're produced and how a picture can be worth 1,000 words, and lay jurors can understand when they see the best demonstrative. So tell me a little bit about how you communicate to the party that creates them.
Yes. So I finalize my report, right? So my analysis, which would have schedules, it would have a summary schedule of my opinions. It would have then the subschedules with the support. So all of that information gets submitted before a deposition and also before trial. So if you have any revisions between your deposition and trial, you resubmit, which you should do most certainly if additional information becomes available and you need to correct the opinion. It's very important to present the most accurate testimony possible on the trial date. And so once my report is submitted, then the team that works on the demonstratives has access to that information, and they typically work off of my summary schedule. Yes, so they pick the information off of my summary schedule usually and make demonstratives. They will use icons many times. If it's a transfer that went into some personal type of an expense, there might be an icon just representing that visually, hotel image or some sort of something that would stand out, right? The dollar living. So, but ultimately, it's not about presenting multiple lines on the screen, but it's just condensing it to 2 to 3 items that they can actually visualize, and most jurors were taking notes. So that was impressive.
A lot of the time on the other side, they're trying to impeach your credibility. They're trying to impeach, what you're saying in respect to the facts of the case and maybe even your demonstratives. How do you deal with the other side, throwing a few left hooks at you and saying, oh, this person doesn't know what they're talking about? What types of strategies do you use to deflect that and to prevent it from happening in the first place?
It surely happened. And number one would be know their strong point, the opposing side, and be prepared to address them. And one way to really know, for example, I read my own deposition transcripts leading up to the trial several times. I read several times, in fact, 3 times, and I noted that one number was different in my Excel that I was looking at live than what I had testified to in my deposition. It wasn't a material number because it was not actually the damages figure that I was calculating, but it was a comparable number. And when I noted, I realized that in later pretrial exhibit submission, somehow my Excel links had changed and I had not caught it. So I was ready to address that point if it came up in my cross-examination, and it did. They brought it up, even though it was not something that it was not actually the damages figure. It was really irrelevant, but they brought it up and they said, "Well, this changed. You testified this, and now in this trial exhibit, it shows it's $300,000 off." What happened? And I was ready for it. So I said it must have been a math error. I did not intend for it to change. Something happened with Excel. But the important point is that it does not affect my opinions in any way.
So getting out in front of it and being ready for it is your advice. Yeah, that's great advice, especially when it was an immaterial error. Which can happen when we're using all these sorts of software. Let's back up a little bit and talk about a few of the more general areas of expert witnessing. What do you find important about being an expert witness? Or put another way, why are expert witnesses important to have?
I think they make or break the case because they tell the story, and the story is substantiated as a result of their experience. So being the expert, also you have this ability and skill set to be creative and understand how damages can be quantified in a case that may not be so obvious, which really happened in my arbitration case. And it was one accounting method that was compared to a post-incident accounting method by the opposing expert. And it should not have been, because the 2 accounting methods were practiced by 2 different entities, meaning, one entity could bill on contingency fee basis, where the other entity was actually by law forbidden from billing on contingency basis. It had to be time and material. Yet the opposing expert compared the revenues and assumed the decline in post-incident revenues or billings was due to economic factors unrelated to the incident, and assumed there is no loss compared to the pre-incident billings. But the two billings had completely different dynamic, and you were comparing apples to oranges. In other words, it was not the same. So an expert a true expert, I would say, would identify those subtle differences and really paint the picture of what really happened and present the findings.
In that case, were you the plaintiff's or the defendant's witness?
I was on the plaintiff's witness.
Did they give some of their objections via a rebuttal report? Was that something that you got to see through discovery? So were you ready for it?
That is correct. Yes.
Tell me a little bit about that. So either on either side, either as a plaintiff receiving a rebuttal report from the defendant, or as working for the defendant writing a rebuttal report against the plaintiff. Tell me a little bit about the dynamics there.
Yes. In this particular case, their main point was really they did not even they would rebut without offering an alternative. So that was a big thing, because if you're rebutting, what's the alternative in my opinion, right? So what would you do instead? But that was not offered. It was simply a rebuttal. Well, the rate she used is not reasonable. Okay. What's a reasonable rate?
Right.
Or the actual difference in billing practices was not even addressed. So what the labeling was used by the opposing expert as this is how the economic damages should be measured, because the post-incident billings represent what actually was billed and generated, and therefore it's the amount that would be technically due, but the billing practice was not addressed. And so he completely really ignored that meaningful difference.
Wow.
And at the end, the arbitrator understood and awarded according to, our analysis, which was great.
So a lot of experts, when they're very first getting started, they don't quite understand the complexities and the sizes that some of these trial teams can be. There's not always just one expert witness. There might be a damages expert, there might be a forensic accountant, there might be all these different experts who are on the same side. In addition, there might be paralegals and assistants and multiple attorneys. They can be quite large. To what extent do expert witnesses work with other members of the trial team?
Yes, the trial team is very important. I would say in the trial that I was in that lasted several weeks, it was imperative for me to stay in contact and communication with the counsel, co-counsel, the paralegal, like you said, on daily basis, really, to stay on track on the testimonies that were being offered throughout that time, and reviewing transcripts as needed, and also staying on top of your analysis. So your work does not stop. I continued reviewing transactions. I continued reviewing my report and offering support even throughout that process. Now, when it comes to working with other experts, in the arbitration case, I worked with our valuation expert in my firm. I do have valuation background. However, it was important for me to ensure that the valuation was accurate and in line. And I worked closely with the appraiser in my firm, which was a great experience, really. And I think it really strengthened our testimony and was well supported and documented as a result, because I made sure I spent the time to understand all the components of, offering the valuation also as part of the analysis.
Let's talk a little bit about relationships. When you are very first getting started in a new engagement, what are the things that expert witnesses and attorneys should be doing to get off on the right foot and then maintain that momentum to have a great, a productive, efficient, and effective expert witness engagement? What are the qualities?
I think it's important, number one, to know what your deadlines are first, and if discovery is open, because that will drive what additional information the expert would need, possibly, and if you still have the ability to request that information through counsel, through subpoena. So one of the first questions I always ask is, what are the timelines we're looking at, and when does discovery close? And
Sure.
what other experts are involved, such as, for example, a vocational rehabilitation expert on a personal injury case, for example, a real estate expert on a real estate dispute case, a corporate governance expert on a partnership dispute case. So it will make a difference, because many times you could likely defer certain bases in your opinions to these other experts.
Sure, absolutely. Have you had any bad experiences, or are there any red flags that give you pause on whether or not you should accept a engagement in the first place, or things that once you have started that engagement that can give you a little bit of pause and make you want to reevaluate that engagement?
Yes, I would say it's important to see what legal team you're working with, and what type of information they're presenting to you, and what kind of case expectations they have. And if your initial assessment indicates things that may not look quite so, uh, I make I go the route of communicating that information and establishing an understanding that I believe this is how, the case might evolve, as opposed to what counsel may have ideas on. And I've also seen where certain experiences of legal team are questionable, where I'm asked about the types of forms that might need to be filed. But as long as they do their side of work, maybe they're a new legal team, or they're gaining their feet on the ground, and sort of establishing trial experience, and I don't mind contributing to their knowledge and experience in that way. That's always nice.
Have you worked in a variety of different venues? On one axis, we have things like different states, different levels of government. And on the other axis, we have things like, criminal versus torts, things like that. Have you worked in a variety of different venues? And if so, what are some of the differences for expert witnesses working in a new venue that you haven't worked in before?
Yes, so federal court is different from state courts. In federal court, you submit different types of reports. You have to submit a narrative report that is pursuant to Rule 26, the Civil Code, and it's a rigorous report. So your opinions have to be pursuant to those regulations. Whereas the state court, you have the option of submitting just analysis exhibits as your report, which is, I think, helpful, because when you don't put things in writing, actually, it gives you a little more sort of opportunity to dive into the analysis. So when I have the exhibits, just know your report regardless, because it should not be the different, right? So I always look at it as one. If I'm submitting it to state court or to federal court, I look at it as one and the same. And also in family court, however, things are quite different. So that's entirely different venue from state and federal court for civil procedures. And family court has its own. I always say I have to wear a different hat, essentially, because it's just different dynamics altogether. And then obviously there's the mediation and arbitration. And in mediation, I heard one time one attorney say, that mediation is the last time the client makes a decision for themselves. That's the last step. After that, either a judge makes a decision, the jurors make a decision, or a combination of both. So mediation that's when, and I've been in mediations involving family law matters. It takes a long time, but I've seen less successful endings in mediations. So, but, arbitration is another step, and arbitration has its own merits. And sometimes it tends to be, the whole purpose, I think, is for it to be less costly than a trial. But the trial is nice because you get your verdict right there and then.
Absolutely. Before we wrap up, do you have any last advice for expert witnesses or attorneys working with expert witnesses?
Communicate with the expert, keep them in the loop on developments and updates, and the strategy, be aware of the strategy of the case, and know your documents and records, and know your opinions and the work performed, even though you have support team assisting. Correct. You're not many times you have many helping you on a case, but know your analysis, know your report, be prepared on various fronts, and try to see different scenarios that could come up in that set of opinions.
Sage advice. Ms. Torossian, thank you so much for joining me here today.
Of course. Thank you for having me.
And thank you, as always, to our listeners for joining us for another edition of Engaging Experts. Cheers.
Thank you for listening to our podcast, Engaging Experts. Our show notes are available on our website, roundtablegroup.com.